Yeah, that's all. The point is.
Hey, just another check going in there.
The House is resumed. Members, we are debating the first reading of the Prisoners and Victims Claims Continuation and Reform Amendment Bill. Charles Chauvel had the call. He has 8 minutes remaining. Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, before the dinner break, I'd just gone through the history of the series of bills and acts to which this is the successor. And I was about to make the point that the original legislation, because it was very experimental in nature and because it was responding to a particular problem at a particular time, unusually for our parliamentary practice, contained a sunset clause. And I think that's an indication that very much this House was enacting the original Act on a wait-and-see basis. Is this novel approach going to be one that we want to persist with? Is it going to work? Is it going to be practical? Is it going to be effective? And I think the history of the legislation is instructive. There's been a low level and a low number of claims that have been made under it. But when the Minister came to me last year and asked me whether, given the approaching date of the sunset clause's effectiveness, it would be in order to extend the Act for another year, in order to negotiate as between the parties in the House what the form of the new legislation, if any, on this basis ought to be. I said that I thought that would be fine. I think the issue now is that we need to look at the adequacy of what is being proffered to the House. And I have two problems with it, and they're problems that both the Honourable Phil Goff and I foreshadowed extensively in the debates around the legislation that extended the sunset clause. The first problem is this. This is supposed to be victim-centric legislation. This is supposed to be legislation that says from this Parliament to those who suffer the horrendous consequences of crime, we want to do something to show that we understand that that is an awful situation to be in and that you have a right, where possible, to be made whole. This legislation does that by saying if a person in custody or under supervision in custodial terms receives a payment from the Crown, then a procedure exists by which that offender's victims can recover some money from effectively the offender in token of the suffering that they have gone through. And that on its face sounds really good, and it's something that we've supported. But the question has to be asked, why stop there? What happens if an offender receives some other form of windfall that isn't from the Crown? What if the offender receives a bequest or a legacy while they're in custody or detention or otherwise under supervision? What if they receive a lottery win? These questions are not addressed, and yet they ought to be, because this is supposed to be legislation about those who suffer the adverse consequences of crime. And if we're serious about putting in place a regime that looks after people in that situation and does make them whole, we as a Parliament should not be concerned about the source of the windfall payment that comes into the hands of the offender. We should simply look at whether or not there is such a payment and then subject it to the process in the bill. And this legislation doesn't do that. It is, for all its masquerading as victim-centric, actually punitive in respect of the offender. And I think, sir, that brings me to the second objection that I would raise in this debate, and that is this. We've always had a tradition in this country and in the common law tradition that we inherited against double jeopardy. The law and the Constitution say that there should only be one punishment for a crime. Well, if that's right, then it's wrong in principle to say to an offender, not only will we take away your liberty, but if during the course of your time in custody or supervision you come into a payment, we will also take money away from you and pay it to someone else. And the second problem I have with this legislation, sir, is there's no recognition, and this is something that the Minister told the Herald last month that she would take pains to address and hasn't. There's no recognition that there's a real danger here of punishing people twice. I think there should be a provision that says if somebody's in custody, they come into funds which are then to be paid to the victims of their offences. That should weigh as to their penalty. The parole board, for example, should have to take that into account in deciding whether or not they ought to serve their full period of custodial sentence or other sentence. And yet there's no recognition of that principle or provision in this legislation. So, sir, I think we need to take real care as to how we proceed in this case. This legislation, as I said earlier, was always experimental. It was always a response to a particular series of circumstances at a particular time. That's why it had a sunset clause in the original Act. We then saw the High Court, the Court of Appeal and the Supreme Court address the cases which led to the particular concern. At the same time, we saw the Department of Corrections smarten up its Act considerably. Those two matters beg the question of whether the legislation remains necessary. And then we have these two other flaws, the fact that although it appears to be dressed in victim-centric clothing, this legislation is actually very much about doling out extra punishment, and it does therefore offend an important principle. Finally, sir, on top of that, we had the assurance from the Minister that there would be consultation about the form of this legislation. There has been none. And, sir, for all those reasons, the Labour opposition will not be supporting this legislation.
Tim McIndoe.
Mr. Speaker, it seems to be my permanent lot in